All right, we are live. So, Chris Berry, certified LO attorney, certified financial planner with Castle Wealth Group. We like to do these weekly wisdom webinars every week where I log in, answer questions that people have or things that they brought up throughout the week, or cover timely concepts for legal, financial, and tax planning. I always like to start with positive focus, just something positive I hope happened over the last week. And last night just had my son's last band concert as an eighth grader. So that was kind of fun. He's going on to marching band next year in high school. And then my daughter has one performance next week. So that's pretty cool. But with that, let's go ahead and get started. And again, if you do have a legal, financial, tax question, feel free to put it in the Q&A. Otherwise, what I have today is just a couple of things that kind of the big threats right now. Earlier today, I just got done presenting some of those concepts to CPAs for continuing education for them. So it was about a group of 20 CPAs that in Southfield I was presenting, and then presenting to another group tomorrow. And a big part of it is talking about what are like the big threats that we're seeing. And so really the two main threats that we're seeing, and this has been an ongoing thing and we've talked about it, is government and long-term care costs. A lot of times from an estate planning perspective, we're talking about avoiding the guardianships, conservatorships by having our disability documents in place. That's going to keep the government out of our affairs while we're alive. And then the other big thing is avoiding probate, keeping the government out of our affairs when we pass away. That's through avoiding probate. The way that we do that is by understanding estate administration. How do assets transfer? Joint ownership, beneficiary designation, or trusts. If it doesn't pass through one of the first three, then it ends up going into probate. So that's from a legal perspective. But now let's talk about it from a tax perspective. And really, there's three main taxes that we have to worry about. First is the estate tax. So when you pass away, the government takes another swipe of your assets, but they've been nice enough to give you a coupon or exemption amount, meaning as long as you pass away with less than the exemption, you owe zero in estate taxes. That exemption used to be $600,000. Now, this year, for a married couple, it's $26 million. So as long as you have less than $26 million, as a married couple, if you pass away, zero estate taxes. For a single individual, that right now is about $13 million. Now, understand that is set to be lowered in 2026 due to the Tax Cuts and Jobs Act. So what's going to happen in 2026 is that estate tax exemption is going to drop to about $7.5 million for a single individual and $14 million for a married couple. So one of the strategies that we've been talking about is if you are in that, say, $7 to $20 million range, there's some things that you probably want to take advantage of now before the tax laws change in terms of gifting or looking at estate tax protection trusts. Just because the exemption, it's a unified credit. So your estate and gift tax, you have a lifetime unified credit of $26 million. So if I gift $1 million this year, when I die, I can only leave 26 million. But that credit is set to drop to, for a married couple, about 14. So the government and the IRS has said through a private letter ruling that if you make gifts from the estate now, you're grandfathered in. So this more applies to people anywhere from about 7.5 to say 20 million of assets. So for majority of people, you don't really have to worry about the estate tax. Likewise, the gift tax, you have that annual exemption, which this year is 18,000. But again, if you gift more than 18,000, all you have to do is fill out a gift tax form and you're just cutting into your unified credit, which right now is $26 million. So gifts really aren't an issue. In fact, we're strategically doing some gifts in certain families right now. The big one is income tax, though. And more specifically, as it relates to your 401ks and IRAs, your traditional accounts, your tax deferred accounts, because these accounts, and I just got done with a meeting with family, we're kind of going over the different tax buckets of taxable and tax-free and tax deferred. And so if taxes go up, the value of those tax deferred accounts, like your traditional 401ks, traditional IRAs, the value goes down taxes go up 5%, you just lost 5% of that account. So we're looking at that through this lens of taxes going up, because again, the Tax Cuts and Jobs Act is going to expire in 2026. And what that means is your marginal income tax rate, all things being the same, is going to go up about 3 to 5%, where 12% is going to 15%, 22 is going to 25, 28, or 24 is going to 28%. So the idea is to look at strategies like Roth conversions or trust conversions, strategies to move money from these tax deferred buckets, looking at your tax bracket, figure out how much more money to pull out. I was just sitting down with the family as we are going over this, and they were coming in at just over $100,000 of total income, not doing anything else right now. So that puts them at the bottom of the 22% tax bracket. So what we can do this year is pull out up to the top of the tax bracket, which is about $200,000. We could pull out an extra $100,000 paying the tax now at a 22% tax rate, versus if we wait until the Tax Cuts and Jobs Act expires, then that 22 is 25%. Plus, we're $34.5 trillion in debt, so taxes might go up much higher in the future. So one of the things that we're recommending is if you have pre-tax 401ks, IRAs greater than say 250,000, looking at some type of strategy moving forward to try to minimize taxes. And I'm not suggesting paying all the taxes in 1 year, though some people do that, but just having some type of strategic tax plan. Because also, not only are we trying to make your retirement more tax efficient, but because the Secure Act passed in 2019, what that says is if the kids, anyone other than the spouse, inherit this money, instead of them being able to stretch the taxes over their lifetime, they have to pay all the taxes within 10 years. So really what we're trying to do from a tax perspective is minimize taxes, not through a micro lens of minimizing taxes in one specific year, but really looking at taxes through a macro lens of minimizing taxes over your lifetime and what we leave as a legacy to the kids. So this is where not only being an estate planning attorney, but also a certified financial planner and having a CPA that's affiliated with us, we're putting together one unified plan to avoid probate, protect against the threats like taxes. And then the other big threat that we need to be concerned with is long-term care costs, because those have been just skyrocketing. And this is a recent article about Nobel Prize winning physicist. He had to sell his Nobel Prize for $765,000 to pay medical bills. And a big part of the medical bills were nursing home costs. And so that's where we see long-term care costs as another big threat as people are moving into retirement. And what we see is what we call the elder care continuum, people living at home relatively healthy, and then as they age, they need more and more help. And that could be home care, which can run $30 an hour or a couple $1,000s a month. Could be independent or assisted living, which could run $3,000 to $5,000, $6,000 a month. Could be assisted living with memory care, which could run $6,000 to $9,000, $10,000 a month, or it could be nursing home care, which could run $10,000 to $15,000 a month. And the average stay in a nursing home is about 2.5 years. I've had some clients that never set foot in a nursing home. I've had people say their mom's been in a nursing home for 7 to 17 years. And understand, 1 out of 2 people will need nursing home care. 3 out of 4 will need some form of long-term care. So that really gives us only 6 ways to pay for it. We can private pay out of our own funds, spending down our 401ks, IRAs. We can have the kids pay. A lot of times they don't pay financially, but they pay in terms of their time, where they're taking time out of their day to visit the elder law attorney or putting their life on hold to become a full-time caregiver. Medicare, or third, is long-term care insurance. And there's different types of long-term care insurance. I'm not a huge fan of trying to get pure traditional long-term care insurance. That's kind of the old style of long-term care. And if you already have a policy, I'm not saying just drop it, but there are some problems with it in terms of premiums going up, companies getting out of the business, and then if you don't use it, you end up losing it. So I was talking to a client the other day. They have an old traditional long-term care insurance policy. They got through a group policy, so they're paying a really good rate. But the question is what to do moving forward. And so in that situation, they're going to continue to pay it. But if there is another premium increase, we're going to reevaluate that long-term care insurance. The fourth way is Medicare. Now, Medicare doesn't really pay for long-term care. It pays for short-term rehab, where if you fall, break your hip, you go to the hospital for 3 days, you can be discharged and have up to 100 days Medicare pay it. You might not get the full 100 days. You have to continue to rehab. And then fifth is the VA benefit, veterans benefit. So it's available to veterans and surviving spouses who are paying out long-term care costs. And then the last way to pay for long-term care is Medicaid. Medicaid's really only going to pay nursing home care. It's not going to pay for home care or assisted living traditionally. And then Medicaid has that asset test where a single individual can only have $2,000 worth of countable assets. A married couple at most can have $140,000. And we have different strategies to plan for nursing home care in Medicaid. We can pre-plan where we set up an asset protection trust like a Castle Trust, and we try to make it the 5 years because Medicaid has a 5-year look-back period. Or if you have a loved one in a nursing home now or on the verge of nursing home care, there's things we can do at the last minute. We call it Medicaid crisis planning to try to protect at least half of the assets. But so that's really all I wanted to cover is just the two main threats that we see. The two biggest threats that we see. One is government, long-term care costs being the other one. So hopefully that was helpful. It was just top of mind because it was part of a presentation I had for those CPAs today and that I'm going to have to do tomorrow to other CPAs. Here's a question that comes in. And if you do have any questions, feel free to put it into the Q&A. So let me copy this question and then take a look at it. All right, so here's the question. Let me share my screen so everyone can see it. All right. So capital gains. So the first house was purchased 60 years ago for $7,500. Husband passed 7 years ago. Do we need to keep receipts for home improvements? Do we need to pay capital gains? Can you tell in general if we need to do anything prior to selling? This would be a good question for our CPA. I know enough to be dangerous, but here's what I would say. First husband passed 7 years ago. So first question is wife still alive? If wife is still alive, there are certain exemptions. Excuse me. There's certain exemptions for the primary residence, as long as it wasn't like a second house or something like that. If I remember correctly, like there's a 250,000 exemption for your primary residence, 500,000 if you're married. And again, this is off the top of my head, and I'd have a CPA confirm it. So most likely, I would say if you were to sell it, wife's still alive, there's not going to be any capital gains. And then if, let's say, dad died and now it passes through death, like a ladybird deed, which is a lot of times what we do. So if we do a ladybird deed and now it goes to the kids, then you get step up in basis. And the way step up in basis works is, let's say we bought it back in the day, 60 years ago, for $7,500. Now date of death, let's say it's 300,000. Okay. And then the kids sell and it's sold for 350. The question would be, how much capital gains would you have? Would it be the 350 to the 7.5? The answer is no, because what happens is date of death, the new basis is what it was at death. So in this situation, if we go from 7.5 to its valued at 350, and then the kids sell, or it goes to 300, and then the kids sell at 350, the only capital gains in this situation would be 50,000 potentially. So typically we're selling the primary residence unless you screw it up, which actually when I was talking to the CPA group today, someone brought up a situation where they kind of screwed it up and they lost the homestead and they got to step up. It was a more complicated situation. And it was a bigger estate. It was like 7 million. And they deeded it from dad's estate to an LLC. But if they would have deeded it to the LLC while dad was alive, they would have maintained everything. So this can be a little bit tricky, but typically if it's just a primary residence, 9 times out of 10, there's not going to be hardly any capital gains. So hopefully that was helpful. All right. And then again, if you do have any other questions, feel free to put it in the Q&A. Someone just wrote it. Yes, wife is still alive, first home. Yeah, so you really shouldn't have any capital gains, but if you do want to verify that, shoot me an email and I'll get with our CPA and get you an answer on that. Can you highlight the Castle Trust one more time? Yeah, so mention the Castle Trust is a way, or asset protection trust is a way to protect against nursing home costs. Let me share my screen here. So Castle Trust, understand there's really two types of trusts that we do typically in our office. A revocable trust that avoids probate, controls the distribution upon death. Both of those things are very important. That's estate planning, okay? Avoiding probate, making sure stuff goes where it's supposed to. That's important, but as a certified elder law attorney, we take it one step further. Elder law being not just planning for what happens if you die, but also planning for what happens if you don't, and you continue to age and face all the issues go along with aging, including long-term care costs. So that's where the Castle Trust can avoid probate, control the distribution, but build in asset protection. So you set up the trust, you move your assets into the trust, and then if you can make it 5 years, then 100% of what we put in the trust is protected from that nursing home or Medicaid spend down. Because Medicaid is that governmental program that can pay for your nursing home care. But Medicaid has a 5-year look back period. So the trick is to set this up, make it 5 years, and then if you're to suffer a stroke and need nursing home care, you could private pay to get in a very nice nursing home. Like the nicest nursing homes you can think of also have Medicaid beds. But if you call up a nice nursing home and say, hey, I want a Medicaid bed for my loved one, they're going to say, oh, I'm sorry, we don't have any Medicaid beds available because they're paid more through private pay than they are reimbursed through Medicaid. But the trick is you set up the trust, you make it the 5 years, suffer stroke, need long-term care. Now you can choose for private pay to get in a nice nursing home, and then you can flip over and have Medicaid pay the cost of care because there's federal guidelines that say they can't discriminate based on source of payment. And so now Medicaid pays that cost of care. You have a pot of resources available to pay for additional services to improve your quality of life. If you're a married couple and one spouse needs long-term care, the healthy spouse isn't completely impoverished. Plus, most people would like to leave this money to their family versus to a nursing home. So that's where we can set up the asset protection trust, make sure you get the best care possible, make sure the spouse isn't completely impoverished, and then make sure the money flows down to the kids versus going to the nursing home. And that's really one of the differences of working with a certified law attorney versus just some attorney that does estate planning. So hopefully that was helpful. All right. Any other questions? All right. Going once, going twice. So